you to do well. A law degree can change lives. Whether it's career, whether it's family illness, whether it's educational opportunities for your kids, a law degree can change your life, and I want you to get it. I'm not trying to trick anybody here, okay? Today's lecture, what I talk about, should be absolutely everything you need for law for this exam. As long as you've been here, it's kind of a refresher. I would sit here and listen. You are welcome to take notes, but we're all different. But I think you'd probably do better if you just listen, because you've heard this stuff a number of times. I'm not saying anything novel tonight, but that's completely up to you, okay? So here we go. Let's begin with talking about contracts. The key elements of a contract: offer, acceptance, consideration, and capacity. Express contracts arise by the spoken word, the written word. They're express. Implied contracts, it's the conduct that establishes the contract. It doesn't make a difference which you have. They follow the same contractual rules. There's also a quasi-contract, which is not a contract at all, really. It's a contract called a quasi-contract because it's the right thing to do, it's the just thing to do, it's the fair thing to do under the facts. Now, consideration is where we began our study. Do not feel when you take the exam, okay, I first got to analyze consideration. If consideration is not an issue, you don't have to tell me about it. You don't have to start with consideration. Should the exam be a series of documents? Last year's midterm, I gave a number of different documents, and what I was looking for was an analysis of what's the communication and offer. You know, they went back and forth. Where was the offer? Where was the acceptance, if at all? That was the midterm question last year. I think they got 2. You're only have 1. But there's 2 parts to it, A and B. But in any event, I didn't need to hear about the consideration in that particular fact pattern last year. It was okay if somebody wrote about it. It wasn't an issue. But the thing is, you would want to begin that type of analysis by what I taught you in class, chronologically looking at each transaction and seeing what it was to see if you found offer and acceptance. So if your exam were like that, you can approach it that way. I'm not a professor that takes off points for you writing about irrelevant issues. Some professors do. I don't, but it will cost you in terms of time. Not so much on this midterm. You've got only 1 essay, which is rare for me. And I guess I'm getting soft in my old age. You've got 1 essay, 5 multiple choice questions.
We are lucky.
What?
We are lucky then.
Yeah. Come back in 10 years, huh? Send your kids. In any event, the multiple choice, 3 minutes is what you need for each question. You don't even need that. The essay, then you'll have you'll have an hour left for the essay, and you don't need an hour for this essay, but you have it, so take your time. You know, I give you 2 blue books, 1's a scrap. I don't limit your pages or any of that. You don't have to have minimum or maximum pages, but take the time to outline. Don't give me garbage. I mean, this reflects your work, so pass in something that you're proud of. I mean, relatively speaking. I mean, how proud can you be during an exam? You're happy to be through it, and I get that. All right. So we can talk after the lecture about any form type questions like that. So consideration, you know, has 2 prongs to it, the bargain and the legal detriment. It's bargain for legal detriment. But promises also sometimes are enforceable on alternative theories, such as reliance, in olden days if they were in writing under seal, and theories of unjust enrichment. Consideration is the most prevalent argument for enforcing a contract. So, what you are looking for is the promisee to do something, to promise to do something, to forbear, or to promise to forbear. And when I say you're looking for the promisee to do something they're not under a legal obligation to do, or promise to do something they have no legal obligation to do. And you're looking for the bargain that goes to and fro, as we said. I taught you early on in January that the court does not look into the adequacy of the consideration. It's not the court's job to measure, was that the right amount of consideration? But you learned this week when we looked at the capacity cases, if there is a suggestion that something else is going on, like incompetency, and there appears to be inadequate consideration or unconscionable consideration, the court will look at that when there's something more than just looking at the adequacy. So typically they don't unless there's something else in the fact pattern that would trigger a heightened scrutiny by the court. It is not necessary that the promisor derive any benefit. You learned that right away. First case is Hammer. You learned that in currency. The promisor need not benefit. All right, let's talk about the pre-existing duty rule. If one is under a pre-existing duty, then there's no good consideration. But a very common multiple choice fact pattern on the bar is payment of debt with a lesser amount. You'd have a hypothetical like this. Debtor owes creditor $1,000. Debtor goes to creditor and says, I don't have $1,000. Will you agree to take $700? Creditor says yes. Takes the $700 and then sues the next week for the additional $3. Guess what? Debtor owes the additional $3 because they were under a pre-existing duty to pay $1,000, and there was no new consideration to support the promise to only pay $700. You need something new or different exchanged simultaneously, such as, I can only afford to pay you $700 of the $1,000 I owe you. If you agree to accept $700 in full satisfaction of the debt, I will shovel out your driveway all fall. Okay, now you've got consideration. Same is true at common law with, well, we'll save that for a minute. Scrap that. Let's talk now about something you wrote your essay for Professor D on contract modifications. That's what your essay was, wasn't it? Yeah, okay. So at common law, a contract modification had to have new consideration. Under more modern law in a jurisdiction that follows the restatement of contracts, if there is unforeseen difficulties or hardship combined with a voluntary promise to pay a modified amount that's fair and equitable before the contract is fully performed, then the modification would be enforceable. That's a restatement view in a modern court. There are some jurisdictions that say, with respect to contract modification, if the parties get together and they modify, although there's no new consideration, but they rip up the old contract, throw it out, and write up a new one, the court would enforce the modified amount. Some jurisdictions will do that. Also, you know, Massachusetts and other jurisdictions say you don't need consideration because you're giving up really an action to sue in damages. And then finally, UCC. Do you have to have consideration to support a modification? No, good faith is all that's necessary. What's the definition of good faith? Under the UCC. Yes. Daniel?
Oh, I'm sorry, I misunderstood.
Go ahead and ask.
Actions that constitute the performance of a contract or partial performance.
No. Honesty in fact, combined with observing reasonable commercial standards of fair dealing in the trade. If you didn't get that, look it up in the UCC. And by the way, I told you when we started the lecture, there are certain topics that this exam would cover, because there's only been a few that we've covered this far. So if I were you, I would go into the exam on Monday with a definition of offer, acceptance, consideration, promissory estoppel, unjust enrichment, indefiniteness, etc. Because you're going to answer the exam, you got to tell me that you know. I don't know what the fact pattern is. I really truly don't remember the essay with particularity. I basically remember it. But you might have to tell me, is this communication an offer? The issue is whether the communication of March 8th is an offer. An offer is defined as, show me that you were in class and you know what the heck the definition is. If you're arguing promissory estoppel, I want the elements, and I want you to apply each and every element to the fact pattern. If you want an A, that's what you got to do. All right. So we've talked about contract modifications. Statute of frauds under the UCC, which I'm going to lecture on a little bit later, applies to modifications. So, if the contract for the sale of goods as modified is $500 or more, that modification needs a writing, if it's between merchants. And if you look, and I'm not testing this, I'll cover this with you in UCC, but if you look at a contract and there's a clause in it about modifications must be in writing, but you have a non-merchant, or it has to be in writing. If you are requiring the modified contract to be in writing and you're dealing with a non-merchant, they have to initial that clause in the contract. So I'll just mention it for now. Promises that are barred by the statute of limitation or discharge in bankruptcy at common law. So a promise to pay a debt that has been run by the statute of limitations or discharged in bankruptcy is nevertheless enforceable. And what I mean by this is, I owe Dean Velvel $1,000 from 1990. Well, that debt is now barred by the statute of limitation. He couldn't sue me on it. Statute of limitations for that debt is 6 years. But I see him next week, and I say, I feel terrible, I'm embarrassed, I am going to pay you that $1,000 I owe you this Friday when I get paid. The subsequent promise is enforceable, because it rested on a real obligation at one time. Same is true at common law for debts discharged in bankruptcy, but today there's a lot of technical requirements. Those wouldn't be tested on the bar exam, the technical requirements. We don't test bankruptcy on the bar exam. Okay, output and requirement contracts. I promise to sell all the widgets I make to you. That's an output contract. We learned in McMichael. I promise to sell all the sand that I can and buy it from you. Requirements contract. No quantity has to be stated. They're enforceable. The limit on quantity is good faith. And I've already given you the definition of good faith tonight. Are you going to have an output requirement contract as an essay? No way. Okay, I've saved that for UCC. Promises implied by the court, the leading case would be Lady Duff Gordon. Court normally is not looking to imply promises. But in that case, you had an exclusive contract. And so even though the agent never made a promise of how hard or how many hours he was going to work to promote the designs, the court said, we're going to imply a promise on behalf of the agent to use reasonable efforts. And so that's the consideration. Even though on its face there isn't any consideration, the court implied a promise to use reasonable efforts only because it was an exclusive dealings contract. I've never tested that I can recall. All right, let's talk about forbearance for suing on a claim. If I have a legitimate claim against you, but I agree to forbear prosecuting the claim I have against you, that's good consideration. The case I told you about in class, that's an important case, is FEIGE, F-E-I-G-E. It's where a unmarried man and women enter into an agreement. She's pregnant, and if she forbears, what they called at the time of the case was bastardy proceedings, he would pay her X amount of dollars for the next 20 years. So they make this agreement, he starts the payments, and they find out the child isn't his. And so he stops paying. And the issue this case stands for is, if you honestly believe you have a legitimate claim, even if it turns out to be invalid, it's still sufficient consideration. If at the time the agreement is made, the parties honestly believe it was valid. Another topic about consideration, and I have seen this tested on the bar, recitals of consideration. In Ray Green case we did. Just because you start the agreement by saying, for good and other valuable consideration, most agreements start that way. You can still prove no consideration was paid. So a recital of consideration in a contract does not necessarily mean that consideration was paid. So just saying it doesn't make it so. So just the words are not the consideration. All right, the bargain aspect of consideration is easier. The promise, the return promise, or the performance has to be, quote, bargained for. One of the issues that arises with respect to bargain is, was it a bargain, was it a gift, or was there reliance? That sometimes is what's hard to decide. Sometimes what appears to be bargain is only a condition to a gift. And so Williston, one of the scholars in contract, said in your opinion, in your textbook, that an aid, although not conclusive, in determining whether something is really consideration or nothing more than a condition to a gift, depends on if the promisor benefits. If the promisor benefits from the happening, chances are it's consideration. So that's an aid, it's not conclusive. Come to my office and I will give you $1,000. Am I trying to bargain for you to come to my office? Is that you're coming to the office just a condition to receiving a gift? It's that kind of analysis. More frequently than not, the issue with consideration is nominal consideration. Nominal consideration, although the courts don't look into the adequacy, is consideration in name only. Nominal. I want to gift my nephew my house for $1,000, another good and valuable consideration. Well, that $1,000 that he pays me for my house, that's worth far more than $1,000, that's nominal. That's a disguised gift. That's not really consideration. Past consideration is not ever good consideration. It's got to be simultaneous with the problem. The promise. You did the taxi cab case and the saving of the life years before. Well, first off, that's only moral obligation. And then secondarily, even if you were in a jurisdiction that followed Webb v. McGowan, which says a material benefit combined with moral obligation is valid consideration, which is a minority opinion. Even if you were in a court that followed that idea, it happened in the past, so it's not valid. Past consideration is not valid consideration. All right, what are the substitutes for consideration? You should be looking for a promissory estoppel if there's no consideration. And in promissory estoppel, you must find there was a promise and it was reasonable for the promisee to rely on it. And the promisor should have known that the promisee would rely. And an injustice would result if you didn't enforce the promise. But the remedy is limited to what how injustice could be precluded. So what I'm saying, let me rephrase that. The remedy under promissory estoppel is what is necessary to prevent an injustice, not breach of contract damages. If you are using promissory estoppel as a substitute for consideration, I do not want to hear in your exam about promissory estoppel till you have told me there's no consideration. Because you always want to try to enforce the contract under traditional contract theory because the damages are greater. They're post-contract condition.
Good question.
Go ahead.
If you see a question and you think that there's a contract, would you still address promissory estoppel?
If you're not positive.
Okay.
If you're on the fence about consideration, cover yourself by saying, however, assuming the court doesn't find consideration, the question is whether an action in reliance will lie. I don't need to hear about promissory estoppel, however, if there's no question about consideration. Yes, the hand was up over here somewhere, yeah.
Even if you're arguing for the other side,
Well,
you're trying to.
it depends the call of my question. If I were to say, you are counsel for Harry, what arguments will you make? You may not want to make that argument. Answer the question I asked.
Just the calling of the question.
The call of the question. And I do that sometimes. I say, what are Harvey's likely arguments? What are Betty's likely arguments? How do you think the court will rule and what? That's a typical Diane Sullivan fact pattern. All right. Let's move on to offer. We're only going to hit the highlights of offer. Otherwise, we'd be here till midnight. An offer, you know, is a communication of a promise, and it's combined with what's expected in return, and an intent to incur a legal obligation. The basic test is this. Someone standing in the shoes of the offeree. Could they reasonably believe they could conclude the contract by acceptance? All right, let's talk about some things that are not offers. Statements of opinion. Statements of intention. I plan to sell my house for $300,000. That's just a statement of intention. That's not an offer. Invitations to deal are not offers. Preliminary negotiations. I bet you 75% of my exams I had at the midterm or final level, I have had some communications going back and forth that are preliminary negotiations only. So watch for that, whether it's on the midterm or final. Statements made in anger or jest are not offers. But remember, that's an objective assessment. Are ads offers usually? No, they could be, but typically they are not. If they're clear, definite, specific, and promissory in nature, then they are going to be offers. All right, the next question is, when does an offer terminate? And the answer is, it terminates as it's specified in the offer. So if I say, I will sell you my car, this offer is held open till March 5th. When does it terminate? March the 5th. What if no time is stated? It's the R word. A reasonable period of time. Another time an offer would terminate is upon death or incapacity of the offeror. An offer can be terminated any time before acceptance. So even if I say, I will keep the offer open for 1 week, it could be terminated tomorrow, as long as it hasn't been accepted. Exceptions to the rule. Firm offer rule. Promissory estoppel can be used to keep an offer open. Part performance of a unilateral contract. Once the offeree has started performance, the offeror loses the ability to revoke the offer. Please distinguish that from mere preparations. But once the offeree has partially performed, started performance, as opposed to preparation, then the offer becomes irrevocable. Airtight. Now let me talk with you about the firm offer rule. I have, under the UCC, have never seen a bar exam without a question about it. The firm offer rule is found at 2205 of the UCC. And what it says is this. If there is an offer to buy or sell goods by a merchant, and it's in a signed writing, then the offer is irrevocable to the period stated in the offer not to exceed 90 days. The question I most often see on the bar is they set up the firm offer rule, but it's not in writing. Okay, it must be in writing to be a firm offer. The period of irrevocability cannot exceed 90 days. It can be shorter, but cannot exceed 90 days. Now, the timing issue. A revocation of an offer is not effective. It cannot be revoked until the offeree gets notice of the revocation. So a revocation of an offer has to be communicated. And if the offeree has accepted, it is too late. So revocation of an offer is effective when received by the offeree. General offers made to the general public, they can only be revoked in the same manner in which they were extended. So if the offer is published Tuesday, Wednesday, and Thursday in the Boston Globe, it has to be revoked Tuesday, Wednesday, Thursday in the Boston Globe. If an offer is rejected, then a counteroffer may or may not have been made, but that present offer is off the table at rejection. The original offer is revoked. If the subject matter of the offer is destroyed, or if the contract becomes illegal, then we say the offer terminates. Acceptance. Manifestation of assent to the deal on the table. That's my definition. You can use it or make up your own. It's assent to the deal on the table. It's exercising the power to conclude the contract. Only the party to whom the offer was made can accept it. You have to know of the offer to accept it. Let's talk about the method of acceptance. The offeror is the master of the offer, and the master can dictate the acceptance be in any manner they wish. But absent that, at common law, the acceptance had to mirror the offer, both with respect to the terms and the mode of acceptance. So I said to you in class, if I sent you an offer by carrier pigeon, you had to accept by carrier pigeon at common law. Today, any reasonable mode is acceptable. The distinction between bilateral and unilateral. Bilateral, promise for promise. Unilateral, promise for an act. We did a few cases to talk about the general rules. Silence is typically not acceptance, and we looked at the exceptions. Where the offeree exercises dominion and control over what was offered, and they know the offeror expects money, then the offeree's silence is acceptance. Sometimes you can use previous dealings to denote the valid acceptance. We review again the notice requirements. In a bilateral contract, promise for promise, offeree must give notice of acceptance. In a unilateral contract, offeree is not required to give acceptance by notice unless it's unlikely that the offeror will know of the offeree's acceptance. Okay, so my early St. Patrick's Day present to you is that 2207 will not be tested on the midterm. It will be tested on the final in some way, but not on the midterm. So, I do want to quickly, though, quick review, a couple minutes on 2207. 2207 is the rule on offer and acceptance under the UCC when there are additional or different terms in the acceptance. So 22071 gets rid of the mirror image rule. Under the UCC, the acceptance does not need to mirror the offer. If the acceptance has additional terms, you treat those additional terms as a proposal to add to the contract. Additional terms equal proposal for addition. Between merchants. Those proposals automatically become part of the contract unless the offer limits acceptance, they materially alter it, or notice of objection is given. This is all found at 2207, for which you have a copy. Different terms never, ever, ever are part of the contract. They knock each other out. Different terms knock each other out. They don't become part of the contract. When you are not dealing with merchants under 22072, any additional terms do not automatically become part of the contract. They just stay as a proposal until the non-merchant assents if they do. Okay, good, you say. Except you learned in the shrink wrap cases, the courts say, even if you're a non-merchant and there are additional terms and they're within the shrink wrap, and you get a reasonable period of time to return the goods and you don't, then the court is reading that now as assent. Shouldn't talk about this tonight because it will keep me up with nightmares. Just kidding. All right, now, sometimes you cannot reconcile the writings of the parties, the purchase order, and the acknowledgement into a contract. The terms are so much in disagreement that you can't result a contract from these writings. But the parties behave as though they have a contract. Goods are shipped, accepted, paid for, nobody reads the documents, 5 months later, there's a problem. It is the conduct that recognizes the contract, 22073. And that tells you, you use the conduct to set up the contract, and the terms will be the terms on which the writings agree. Everything else, you use the standard UCC terms, that's called gap filling. Rest your hand a minute. We got statute of frauds to review and capacity. Okay, MyLegs. MyLegs is the acronym to help you remember what contracts must be in writing. M stands for marriage. Marry me and I'll give you the moon. The giving of the moon, the promise to give the moon must be in writing. Mutual marriage promises do not. All right, why? What does that stand for?
Performed within a year.
Year. Contracts that cannot be performed. No possibility of performance within a year of their making must be in writing because memories grow stale. If I hire you for life, does it have to be in writing? No, because there is a possibility for all of us that we could die within the year. And the contract then would be fully performed because it was a contract for life. So no writing is necessary. What if I hire you for 5 years?
Yes.
You need a writing. Even if you die, you'll be excused, but you haven't performed the contract fully. Because if I hire you for 5 years and you die within 6 months, well, you have not fully performed the contract. You're excused, but you haven't performed, so you need a writing. L. Land contracts, except for licenses, must be in writing. Although you can use sometimes part performance, promissory estoppel, to get around the writing requirement. Okay? E, what does that stand for? E, letter E. Executor. Promise of an executor to personally pay the debts of the decedent must be in writing. People don't do that typically. G, goods. This is the tricky one. Any contract for the sale of goods, $500 or more must be in writing. Now, tell me what are the key exceptions? Yep.
Specialized merchandise.
Specially manufactured goods that can't be sold in the regular course of business. What else? Yes.
Confirmation is sent and they don't say they don't want to go along with it within 10 days.
Confirmatory memorandum exception. Very good. Now, the confirmatory memorandum exception is the one that seems to always be tested on the bar examination. And what the confirmatory memorandum says, and you can find it at 22012, it says, even though there is no written formal contract, because they entered into the contract typically over the telephone, one side fires off a confirmation to the other side. If, when received, it's not objected to within 10 days, the statute of fraud defense is removed. Daniel, you have your hand up.
Oh, I was gonna name the next one.
What's the next one?
The seller admits there was a contract.
Admits it in a court proceeding, deposition, discovery, that type of thing. Suretyship is the last one. Suretyship If Harry doesn't pay his bill to you, I will. If Harry doesn't pay his bill, I will. That is a contract of suretyship. I am promising that if Harry doesn't pay, I will. That is to be distinguished, folks, from the following. I'll pay Harry's bill. What does he owe you? That's not a contract of suretyship. That I'm undertaking original liability. Now I gave you the hypothetical, and hopefully that will help you remember the next point. The next point is, if the reason the surety is making the promise to answer for someone else's debt is for the surety's own benefit, then no writing is required. That's another exception. Last topic of the review. Capacity. If you have a contract, the parties must have contractual capacity. A common type of incapacity is infancy. I would expect a question on infancy on the bar exam. Probably on my final too. All right, an infant at common law was somebody under 21. Today it's 18. So you're going to read the call of the question. But an infant has a personal right to disaffirm a contract up to the time of majority in a reasonable period thereafter. And if they don't disaffirm after attaining majority, we say that they've ratified the contract. The right is personal to the infant. The other side cannot avoid the contract. The infant has to return whatever they have if they disaffirm. But there's no requirement of putting the other side back in the condition before the contract. So there's no requirement of what we call status quo ante. The biggest exception is necessities. An infant who disaffirms a contract, and the contract was for necessities, which is a factual question. If the contract were for necessities and the infant can't return some of the necessities, then they have to pay the fair market value of what they've used up. Not the contract price, the fair market value.
Can you repeat the last one, please?
The last.
They have to,
If the infant has entered into a contract for necessities, and they've used up some of the necessities so that they cannot return them, then they have to pay the fair market value of what was used up. Not the contract price, the fair market value. Okay, mental illness. Mental illness, mental defect. If the parties under legal guardianship, all contracts with the incompetent are void. VOID. If the party is not under guardianship, then the question is, could the incompetent understand, and did they understand, in a reasonable way, the nature and consequence of the transaction that they're engaging in? Did they understand what they were doing? And did the other side have reason to know of the incompetence? If they are not under guardianship, then we say their contractual duties are voidable as opposed to void. The standard for intoxication is very similar. Did the intoxicated person understand the nature and consequence of the transaction? Did the other side know they were intoxicated? Did they move to disaffirm it quickly after they sobered up? Those are the considerations. You are now armed with everything you need for this exam. Questions? Take 10 minutes, and I'll send Professor Martin up to begin for 7. Have a good evening. See you Monday.
You go to a regular or this room?
No, your regular room.
Oh.
What if you pass out? We're gonna get,
I can't hear you.
Our quizzes, where are quizzes?
Where are the quizzes? Who's got the pile of quizzes? Everybody come grab yours so I can take the remaining ones and go get Professor Martin.